number 8.
Maybe.
I appeal for the statement.
That's in item number 8. Milord, I appear for the petitioner in this matter. On 22nd of December, your Lordship had passed an order. I don't know if that order has been complied with, Milord.
But I have secured the instructions, Lord. That your Lordships have directed me to secure instructions as regards what are the documents we have in order to initiate Lord actions under the provisions of KPID Act. Lord, there have been 22 cases registered against petitioner. All these cases have been transferred to CID for special investigation. Special investigation has been going on. 414 victims have filed their claim petitions against petitioner. ROC also has given a complaint against the petitioner, saying that they are indulged in carrying out Ponzi scheme under the franchise of QNet, violating the provisions of RBI Act, Companies Act, everything, Lord. And they have lured as many as 414 victims, Lord, to invest monies. Monies have been invested in various accounts of the petitioner themselves. There is sufficient information, Lord, to initiate action under KPID Act. Complaints have been received. The petitioner has to cooperate with the investigation, Lord. Therefore,
Lord,
Lord, your Lordships may kindly reject this writ petition, reserving liberty to the petitioner to approach the special court where the complaints have already been lodged.
Yes.
Under section 15, Lord, the special court has enormous powers, Lord, to look into all their claims, and then it can be considered there.
Now, may I please, Milord, may I be heard, Milord?
Yes, yes.
Please. Milord, the issue before your Lordship is, Milord, whether this action could at all have been initiated. For the action to have been initiated, Milord, kindly come to the Act, Milord. The Act is, Milord, the Act is at page 117.
Yes, 117.
Yes, Milord.
Yes.
That the action initiated under this Act can only be against a financial establishment. Milord, there is, as far as my business is concerned, I am a direct selling agent. This fact, Milords, has been verified, and there is an order, Milords, of this High Court at page 260, Milord. Your Lordship may come to 267 is the order, Milords. At 286, if my lords comes to page 286, there is a categoric, Milords, internal page 20, running page 286. This is an order of this Honorable Court, Milords, in a writ petition dated 15th February 2017. Lords may come straight away to, because that is where it refers to me. Material of unimpeachable character pertaining to the activities of QNet have been produced before court. A perusal of the material and the charge sheet averments prima facie indicate that activities of QNet and Vihaan, that is the present petitioner, that is a multi-level marketing companies, do not constitute offenses under the price chit and money circulation schemes. The activities of the company do not fall within the definition of money circulation scheme under section 2C of the Act, nor does it fall within the definition of price chit under 2E of the Act. When the activities of these companies do not constitute any money circulation scheme or price chit, the offenses under 4 and 5 of the Act do not even remotely apply to such activities. The report of FICCI also specifies that in the absence of a clear legislation and regulatory framework, the multi-level marketing companies have led to severe problems for such companies operating in the country. The present case clearly demonstrates the fact that legislation such as price chits and money circulation, etc., which do not even remotely apply to the activities of a multi-level marketing companies, are applied to by the investigating authorities, leading to disastrous results. Look, my business, it has been held to be legitimate of a direct selling agency by this court. And as far as the various FIRs are concerned, petitions at page 260 onwards are orders of the Honorable Supreme Court. When they initiated action against us, Milos, we have filed petitions in the Supreme Court, page 260 onwards.
Page 261.
At
Yes.
page 261, Milos,
Where is that?
for the ground stated in the writ petition, Milord, does my lords have page 261?
Yes, yes.
260 is Vihaan.
At 260, if your lordships comes to Milord, Vihaan Direct Selling Private Limited, the
Yes.
present petitioner. Cause title. We have heard learned senior counsel appearing for the parties, exemption allowed for grounds stated in the writ petition. There shall be stay of further proceedings in all the 20 FIRs. This relates to 20 FIRs. Next order, Milords.
This is the same.
Milords, next order is at page 266, Milords. Again, Vihaan. Once again, no coercive action against the petitioners in the meanwhile. In the while this order subsists, Milord, these orders at notifications at page 82 and 104, which is nothing but a coercive action, has been taken. These orders have been passed on a presumption that I'm a financial establishment. There must be something to show that I am a financial establishment. Once it has been found that I am only a direct selling agency. The basic issue before your lordship today is whether any action could have been taken under this act, which has been, Milords, enacted for the protection of interest of depositors in financial institutions, page 117. Look at the object of the act. Whereas it is expedient to provide for protection of interests of the depositors in financial establishment and the matters relating thereto, and for the purposes hereinafter appearing. Section 2, Milords, of this. Next page, a 118 deposit. It includes and shall be deemed always to have included any receipt of money or acceptance of any valuable commodity by any financial establishment to be returned after a specified period or otherwise, either in cash or in kind, or in the form of specified services with or without any benefit in the form of interest, bonus, profit, or in any other form, but does not include, Milords, your lordship, Milords, am emphasizing, but does not include, Milords, the following. Please come to clause 5, subclause 5. Amounts received in the ordinary course of business by way of advances against order for goods and services.
5D.
5D. Not an independent authority, anybody has to, Milord, first there has to be a finding that I'm a financial establishment.
But does not include that if the government because it is always the public what is the complaint. It would satisfy.
They should not.
Take any coercive
Portion.
from Supreme Court order.
Yeah.
Where is this?
Yes,
Milords, and please see at page 293, we have been issuing public notices where we have categorically said, Milords, 290, Vihaan Direct Selling India Private Limited is a direct selling agency and it's a law-abiding. Milords, the prints are a little small.
So page 292 is bigger one.
Sorry, Milords, page 292, I'm told the print is slightly better. I will come to 290.
This is the
QNet.
not 46.
Milords, in fact, that very specifically says the company does not solicit investments, take deposits, promise fixed returns, sell shares in the company, sell or offer jobs through intermediaries, offer any sub-franchisee opportunity. How have I been misleading the public? In the national English daily, in the national regional language papers, these advertisements are repeatedly given. There are others also, Milords, page 290, 292, 293.
You are basically
A direct selling agency, Milords.
direct selling agent of QNet
Yes, Milords.
who are involved in the business of
They are, Milords, an international firm. They have all over the world,
Just-
Milords, they are selling.
just a minute.
Yes, Milords.
In order to understand, we want to know it.
Yes, I'm sorry, Milords.
Various products in category of home care, personal care, skin care, health food, supplement, watches and holiday packages, etc.
Page 12,
This-
Milords, I have set out the
This
details.
page 292, the
Yes,
notice which you have read,
Yes, Milords.
this shows that QNet has appointed you as the direct selling
Agents.
agent for these products.
Yes, Milords. Please see, Milords, page 12. I have set it out, Milords, in my petition. The petitioner's business, Milords, page 12.
Page 12.
Page 12, writ petition, Milords. The petitioner's business.
Yes.
The petitioner is an e-commerce based direct selling company. The petitioner has more than 4 lakh customers in India. The petitioner is a sub-franchisee of QNet Limited, Hong Kong. QNet Limited is one of the largest direct selling network groups in the world with a customer base of 60 lakhs in 150 countries and a portfolio of 80 products. The petitioner sells various products in India, such as water purifiers, nutritional products, jewelry, watches. A copy of the product brochure is at 139. Direct selling refers to selling products and services directly to the end consumer without traditional retail shops.
Now, what are the allegations made against you? How you are involved in financial activities?
Milords, kindly
What-
see what they have said, page 82. That is, they have just published a notification. There is nothing, I'm not issued any show cause notice. Nobody, there is no finding that I'm a financial establishment. Somebody said, says, Milords, page 82. It has
Yes.
come to the notice of the government that the financial establishment versus Vihaan Direct Selling Agent India Private Limited, QNet company, is involved in fraudulent transactions and failed to return deposits to their depositors. There's no notice to me. There is no, nobody has come to the conclusion that it has come to the notice that I am a financial establishment. Milords, how does this act, that's how I'm challenging this act, There must be some show cause notice. My lord, all FIRs that are lodged have been stayed by the Supreme Court. My lord, would the Supreme Court, I ask myself, just stay an FIR without there being any substance before it? And all those FIRs have been lodged by some, my lords, big. So the issue before your lordship today is, my lords, whether any action could have been initiated under this act. And that is not what the competent authority or the special court, my lord, if your lordship comes to page 12 of the act. What are the powers? Powers are only distribution. They are like an executing court, my lord. Page 12, section 12. Special court is page 128 is special court. For the purpose of this act, the act is for returning money, getting the money of the depositors. For the purpose of this act, the government may, with the concurrence of the Chief Justice of the High Court, by notification.
All right, all right. Now we have understood. All right.
Yes. Yes.
Yes, Mr. AGA.
Lord,
Now we had directed you to find out
please, Lord.
as to what evidence has been collected prima facie to show that petitioner is collecting deposits
Please, Lord.
and involved in fraudulent transactions.
Lord, a detailed investigation has already, Lord, happened. One through report has come from Lord Criminal Investigation Department. Lord, 22 complaints, Lord, across the states have been filed, saying that they have lured those complainants to deposit, Lord, the money in order to quick earn, Lord, in a MLM scam run by this petitioner, Lord. But there is, Lord, I may be permitted to furnish the Lord, original records, Lord, which are available with the Revenue Secretary, Lord, before issuing this notification.
Oh, whether they were given any notice
Lord,
prior
if your lordship,
to issuing this notification,
Lord,
impugned,
please,
whether they were called upon.
Lord, this notification at Lord, the page number 82 is issued under section 5(1), Lord. It is only
Yes.
for appointment of competent authority. So competent authority has to look into all these things, the claim petitions. He has to
All right.
verify the claims, make a statement before special court. But secondly, Lord,
All right, all right. Now, you are not producing any evidence to show that they were involved in the financial transactions or had collected deposits. You are only saying that 22 complaints have been received
please,
and 414 victims have been found.
please, Lord.
That is a matter of investigation. So let investigation be held. They will cooperate, but no coercive action.
My lord, your lordship, at page 102
They
is,
should
my lord,
not alienate the
104
properties and
is,
take
my lord,
away the
they've
money.
attached
Lord.
all my accounts.
If the monies are blood taken away, blood, then the competent authority would not be in a position to distribute that money under the very purpose of the act would be vitiated, my lord.
They will cooperate in the investigation. They will cooperate in the investigation, but you will not take any coercive measures.
But
Your lordship,
the orders passed by the Honorable Supreme Court are under a different provisions. They do not pertain to the provisions under the KPID Act.
KPID Act doesn't
All
apply
right,
to
all right.
me, my lord.
Even the order, Lord, the Learned Senior Council has relied upon, Lord, the order passed by this Honorable Court is in a criminal revision petition. Not in this case.
All right, all right. All right.
But in this case, your lordship may kindly see section 5 and 3 for a minute, Lord. The act provides for such an action by the state.
We are not
Only-
restraining you from. We are not restraining you.
Lord,
We are only saying you carry out the investigation.
please, Lord.
They will cooperate in the investigation, but
Please,
no
Lord.
coercive action.
Lord, may I, my lord?
But
But the act doesn't apply
One
to me, my
submission.
lord. If your lordship
All
just.
right, that is a question. That is a question which will be
But some
decided.
authority has to come to that finding, my lord. Your lordship may, my lord, set up a, my lord, some retired judge to go into it. My
All
lord,
right, all right.
Vicky has given a report. In fact, my lords, I have also
That-
in.
That so far as that virus is concerned, that
Not
that
virus,
pleading,
my lord,
let the pleadings be
absolutely.
completed, then that can be considered.
Please,
Lord,
Lord.
but your lordships will not pay 104. They have attached all my accounts.
Lord, your lordship may kindly see
That
section
your lordship
15,
will
Lord,
not
for a
protect
minute.
me to some extent, will not coerce. The Supreme Court says no coercive action, they still go on. They will continue to do it. The Milords, the High Court of Telangana,
Now,
Milords
that was
directed
under
them-
different provisions. It is now under this act,
Milords, but
KPID
that
Act,
act would apply
that
if
they
I'm
will
a
not
fine.
act any coercive.
Milords, your lordship may, Milords, somebody has to go into it, whether the act applies at all. Please see section 12, what the act, what the court, what the special court can
Then,
do.
But
all right, then let them file the statement of objection, then we'll decide.
But all that can be decided by the special court. They can say so
No,
before the
it
special
can't.
court.
This is-
If the special court feels that they have a case, Lord, the special court has
Then
powers
virus
to
cannot
enlarge.
be, virus cannot be decided by the.
But it's not the virus, Lord. Your lordship may kindly see section 15,
The
Lord.
relief which has been sought for is challenging the virus. Can we remit it to the special court?
But your
You
lordship
file
may
your
kindly see
objection, we'll
section 15,
consider the
Lord.
virus of it.
Let pleadings be completed, my lord. Your lordship may pass an order, no further coercive action will be taken, my lord.
Yes,
But
this is
the-
what we are saying. You are insisting that this act does not apply.
Can't decide it at the interlocutory statement.
Lord, your lordship may kindly see section 3 for a minute.
Yes.
We'll consider it, madam. First, file your pleadings. Can we pass
You
any
will-
orders today without your pleadings?
Please.
Or is it your case that you will argue the matter without pleadings?
Lord, I have been asked to, Lord, secure
All right.
records.
All right. All right. All right.
File it.
Heard? Madam Indra Jaising, senior
No, my lord,
advocate.
I'm Kamini Jaiswal.
Family.
Oh, I'm sorry. Kamini Jaiswal, Leonard senior advocate, assisted by
My lord, Rohit Singh. And
Rohit.
my lord, there is somebody from
Krishna.
Karnataka itself.
Malots Krishma and Malots.
Ishmael. The the senior advocate appearing for petitioner submits that the impugned notification dated 29/6/2021 has been issued without providing any opportunity to the petitioner. It is the categorical case of the petitioners that they are not involved in soliciting investments, taking deposits, promise fixed returns, sell shares in the company, sell or offer jobs through intermediaries, offer any sub-franchisee opportunities. Full stop. In fact, the petitioner is e-commerce based direct selling company. The petitioner has more than 4 lakh customers in India. It is a sub-franchisee of QNet Limited, Hong Kong, which is one of the largest direct selling network group in the world, with a customer base of 60 lakhs in 150 countries and a portfolio of 80 products. The petitioner sells various products in India, such as water purifiers, nutritional products, jewelry, watches, etc. It is submitted that the Honorable Apex Court in the writ petition 17 of 2019, Vihaan Direct Selling India Private Limited and others versus Union of India and others. No, sorry, not this one. बात बोलो ना।
266.
Page
In
266.
criminal petition number 9208.
266. Good. No.
No, no.
नहीं, अभी
Lord,
पढ़िए।
page 260. my lord.
In criminal petition number 9308 of 2016, while order dated 15th of February 2017 has
Lord, I'm sorry, my lord, I'm interfering, but that is the Karnataka High Court. That criminal 9308 is
this
Karnataka High
order
Court.
which you had shown at
I have
page
read at 260, my lord.
66.
Writ petition number
6.
31 of 2017.
Okay, just a minute. What you will say? In writ petition number 17 of 2019 has party's name you have written, no? Has provided that no coercive action shall be taken against the petitioners in the meanwhile. The matter is pending before the apex court. It is also submitted that in criminal petition number 9308 of 2016, this court, by order dated 15th of February 2017, has held that perusal of the material and the charge sheet evidence prima facie indicates that the activities of QNet and Vihaan, that is the multi-level marketing companies, do not constitute offences under the price, chit and money circulation scheme in bracket banning bracket close Act 1978. The activities of the company do not fall within the definition of money circulation scheme under section 2 in bracket C of the Act, nor does it fall within the definition of price chit under section 2 in bracket small e of the Act. When the companies of these company do not constitute either money circulation scheme or price chit, the offenses under section 4 and 5 of the Act do not even remotely apply to such activities, and consequently charging the accused of such offenses is unsustainable. It is also submitted that the report of FICCI also specifies that the absence of a clear legislation and regulatory framework for multi-level marketing companies have led to severe problems for such companies operating in the country. Full stop. Learned AG, on the other hand, on the basis of instructions, submit that 22 complaints have been received against the petitioner company, in which 414 victims have been found. It is submitted that investigation is going on and the petitioner shall cooperate in the investigation. Learned AG submits that the petitioner may appear before the special court
Please, please.
under the
KPID.
KPID Act and raise objections regarding the impugned notification. Full stop. We have considered the submissions made by learned counsel for the learned senior advocate appearing for the petitioner, and learned AGA for the respondents. Since the virus of KPID Act is under challenge, we hereby issue notice to learned Advocate General in this regard. Let the statement of objection be filed by the respondents within a period of 3 weeks,
Like 4 weeks.
4 weeks. List on 21
Wait.
2 2022. In the meantime, the investigation regarding the complaints filed against the petitioner may go on. The petitioner shall cooperate in the investigation. However, the respondents shall not take any coercive measures against the petitioners.
There's only one thing, my lord. Your lordships have said, my lords, that we are doing this. My basic contention is that I'm not a financial establishment.
Add that in the where you written. Submit that
Understood the act
petitioner is not a financial
establishment.
establishment.
Please put order of this.
My lord, and the Supreme Court order, page 260, is writ petition number 13,
31 of 2000.
31 of 2017, at page 260.
The bail order.
Hmm?
Your lordship has in the order referred to the Supreme Court order, my lord, staying coercive action, but there is a basic, my lord, a very long order at 260 in writ petition number 31 of 2017. Your lordship may refer.
The bail order, man.
That is a bail order.
But
No,
first
no.
line.
The first line, my lords, all 20 FIRs in terms of page 261.
That is bail has been granted.
The long
No, no,
order is
no.
only the conditions of
No,
bail.
no.
man.
For the ground stated, the writ petition, there shall be
Stay of further.
proceedings in all the 20 FIRs. That's important. my lord. That is what I'm relying on.
Page 261.
261, line 4, my lords.
Add that also that it is also
They were under
submitted
the different enactments, my lord, which were considered
in
in
writ
detail.
petition number 31 of 2017. The Supreme Court, while granting the bail, has observed that there shall be history of further proceeding in all the 20 FIRs.
Yes, in the country from Maharashtra.
Where you were.
DP of law.